May I, my lordship? I beg to mention item number 5, my lordship, on behalf of Mr. M.K. Neo. This matter may be listed on 18th, my lordship, coming Monday.
Yes.
The delay condonation. You are for a respondent.
No, I'm for the petitioner.
You are for a petition.
You're making a prayer on behalf of topic.
Yes, ma'am. No, my lord. M.K. Neo.
He's for the respondent.
Yes, my lordship.
On the prayer for the landed council MS. What is your name?
K. Wangmu.
A praying for a respondent.
On behalf.
On behalf of Mr. M.K. Neo,
Yes, ma'am.
the matter.
My lord, here, respondent number 4 has filed the affidavit. Affidavit is required in respect of respondent number 3, who is the deputy commissioner, my lord.
Need some more time, your lordship, to file affidavit on behalf of respondent number 3.
You want to file a reply?
No, yes, affidavit, your lordship, on behalf of respondent number 3, DC.
Deputy commissioner.
You will have to establish your legal right here.
Yes, my lord.
Their affidavit in an appeal, why an affidavit is called for? It's already there, stamp. It's whether the decision is correct or not, that is only to be examined.
Since in the read petition, we had not filed affidavit, so
On the prayer of Ms. Government, the junior government advocate, appearing on behalf of the respondent number 3, and the matter stands adjourned for 2 weeks, enabling the respondent number 3 to bring his stand on record by way of filing an affidavit.
obliged.
Bad.
Yes, Mr. Ratan. Why this should not be interfered with?
My lord,
Huh?
the procedure adopted. My lord, that's why, my lord, yesterday also I tell.
No, it's forget the procedure. She had not given her documents, fine. But subsequently she submitted and you found her eligible for in 22. Now, this is a group C post. You are bringing in the formula of group A and group B here. Cannot be applicable. You should hold the review DPC, consider the case as of that date. Disposed of. Agreed.
My lord, there is a private respondent, Mr.
Yes,
Kato
who is
is
that?
appearing, my lord.
You got a benefit, enjoyed it. Now she should be given seniority over you.
My lord, here specifically, my lord, seniority is not claimed.
Forget
Basically,
it. She wants a promotion from the date you were promoted.
that was the my lord, the whole consensus made before the my lord,
We don't find
single
it.
bench.
We were just having that. We don't
The
find
sing-
it. We don't find it correct.
My lord, seniority is one thing, and claiming, my lord, that this,
We are not, we only can direct that her case will be when the promotion, your case was considered,
my lord,
a review DPC would be held on that day. Her case would be further considered. If she is found eligible, she'll be promoted from that day.
my lord,
And
she is already
seniority.
promoted, my lord.
And that will be given retrospective effect. Otherwise, this cannot be sustained. To want to have an argument, you want to make out a case, we can adjourn. But otherwise, this is review. We are passing an order for review DPC.
What, my lord, submission, my submission, respectful submission is, my lord, the DPC was conducted basing on the merit cum seniority, my lord.
Where? Show
And
me.
the merit and the senior, my lord,
Where?
in
If
the-
it is merit cum seniority, now we will direct that thing. We'll have to redo it. You may not get it also.
now, my lord, in that case, she failed to submit certain documents which is relevant for
You
the
tell me,
consideration.
why is she required to submit a vigilance clearance?
My lord, this is the, my lord, the
It
consideration.
cannot be. It's not supported by the rules.
My lord, what happened in this, my lord, particularly, my lord, in the all departmental promotion committee, my lord, for giving promotion, my lord, one must have adverse record, one must have some, my lord, therefore, NOC
We are
and,
interfering with that practice. That is not called for. An employee is not required to.
my lord,
complete-
that requirement is also not under question, my lord.
Forget it.
So, my lord,
We'll only go by the rules.
It is the, my lord, my lord, admittedly, my lord, consideration, my lord, done by the, my lord, the state government, while considering state, my lord, the employees for promotion, my lord. One has to not only submit, my lord. My lord, in that case, my lord, I may be allowed some more time to, my lord, make out my case, my lord.
But otherwise, this is the order which Mr. Modi is entitled.
My lord, and this is this, she is already holding the.
On the prayer of Mr. M. Kato, learned counsel appearing on behalf of the respondent number
Oh, my lord.
4. List this matter again after a week on a date to be fixed by the registry. Also heard Mr. C. Modi for the appellant and Mr. N. Ratan, additional advocate general appearing for the state respondents. And Mr. Tamang, you are being for?
Madam. For the department.
For?
Two and department.
And also Mr. Tamang, learned standing counsel, education. The name of the learned standing counsel, education department, Mr. P. Tamang, be reflected in the cost list. In the cost list.
My lord, deep level.
Have you not taken steps?
Philosophy, we actually we seek one more week to
And what
take the
is the
steps.
position, Mr. Tamang? Now.
My lord,
Yes, Mr. Tamang.
yes, my lord.
What happened?
No.
Have you appointed a judicial member?
My lord, judicial member, not yet, my lord. My lord, last
But
time,
eligible in the social service for
no one, my lord. Last time someone appeared, but he only for only 6 months, my lord, validity. So that was the reason. Now, my lord, as on that, commission is working. Now, post has been already sanctioned, 30 posts.
that
That's
sanction is long back.
long back, my lord. Yes,
But
long
you have
back.
not filled it up.
My lord, as per this act, my lord, this sanction posts are to brought on deputation, my lord. We are, that is the position, my lord.
By
Tomorrow,
tomorrow.
the learned counsel for the petitioner submits that he be granted a day's time to take steps upon the newly implemented respondent number 4. Prayer granted the petition to take steps tomorrow, failing which necessary orders in the matter would be passed on the next date of listing. List after service upon respondent number 4 is completed.
Hello.
Item number 4. Lordship, this is a case in connection to Bomdila Pokso case 10/2020.
You are for the appellant. You are for the appellant.
Yes, I am for appellant, Lordship. In this case, the appellant is convicted by Lalit for 09/2023. Sentencing that the appellant for rigorous imprisonment of 20 years under section 6 and 366 for 5 years. So now what's shifting is that.
Paper book will be required.
Pardon, Lordship.
LCR or not?
NCR, Lordship, last time it has been called.
LCR. Okay, Hardal Learned Council, Mr.
T. Topu.
Take the point for the appellant. Hard MST Genie, Learned Additional Premium for a state of Assam. You are for?
R3 man.
Hard, Mr.
D Mandal.
Paying for respondent number 2. LCR receipt. Prepared paper book list. Whenever the paper book is ready.
Deeply.
Item number 6.
Basically challenging the shifting of a district medical
Officer's office.
office from Hailuing to Hawaii. Now the difficulty, let me.
Yes, Mr. Thor.
Yeah. No, the difficulty is whether the deputy commissioner has a power to see the of the district medical officer to the
Tell me how you have pitched this. How total going to be affected because of the shifting?
host. It
You are
is
not a government employee, you are not representing government employees. So
But-
where is that question of referral coming in?
that exactly is the question that I anticipated that would be falling from their lords. But kindly see. Any decision taken must have a proportion. In this case, there is no proportionality as well as rationality in decision because
Who have filed affidavits in the matter here, Mr. The affidavits have been filed by.
the health department is supporting my case. Yes,
No, no, where is
genuinely,
that?
there is nothing as such.
Now, where is that health department's
A
affidavit?
health department affidavit, my lord. Sometimes it is difficult to speak on their behalf, my lord. My lord, we'll see this, there is a affidavit filed. They have not mentioned.
No, forget it. I saw that affidavit. Just locate the
Respondent to my lord,
respond number 2.
yes,
Yes. Okay, statistical officer.
yes.
Number 3.
That is no. This is better. Another affidavit is. We'll see the affidavit filed by respondent number 3 is important for me.
Come to page 4, the last paragraph.
Yes. The Hawaii headquarters is located at a distance of 60 kilometers from Hailuing, Swami came, where deputy commissioner. To me, ये सब कुछ छोड़ दो फाइल. Yeah, हमें pick up.
Yes.
Yeah, yes. Well, I proceed reading
See the center point. See that Chaglagam is 50 kilometer away. Then Goilang is 25 kilometer. Then Manchal is 15 kilometer. That is 40 kilometer away from Hawaii. Well, that particular Chaglagam is 100 kilometer away from Hawaii.
Para 16 or 10 to para 16. Come to para 16. That is your case. Petition.
If the district medical officer establishment is shifted, then automatically the various senior program officers, come medical officer, the etc. will also be shifted. This will have an adverse impact on health and service delivery of the district hospital, which will directly affect 70% of the population of Anjo, as more than 70% of the population of Anjo district resides in Haiuling, Goilang, Chaglagam, and Manchal. Hence, this honorable court. So that this is me. Now, para 19 also.
17.
70 years. Submitted as per the guidelines, the office of the district medical officer or establishment has to be set up near district hospital because it requires personal supervision and monitoring by DMO, which may not be possible if offices.
Show me that guideline.
Well, that guidelines we have not put in.
The district medical officer can have no relationship with that hospital. The hospital, the superintendent, is also equivalent, it's on record, to that of a district medical officer.
My lord, let us view this way. Let us view this way.
Hmm.
The contrary view is, and now what had happened is, Arunachal, my lord, the district medical officer, under him there are a lot of program officers. Once the office is shifted there, then all this will be also along with him, and thereby the doctors who are looking after, trained doctors who are treating the patient will be deprived of their right to.
How can you be? The hospital doctors cannot be the health service doctors.
No, my lord, it is not like that. The RHO, these are all trained doctors only, my lord.
No, they don't work in hospitals. They work in offices. They are
No,
administrative people.
simultaneously they are performing the.
Show me that. Show me that.
Well,
Show
that-
me some instance
That
that a district medical officer will also go to the hospital
Does
and
it-
treat patients there.
That does.
Show that.
my lord, there is shortfall of this thing. My lord, that
Cannot be.
contention.
It's two different wings,
No,
Mr.
no, my
Tapa.
lord is not accepting that contention, but the contention that I am advancing before my lord is that whether the deputy commissioner has a power to pass such order.
First, you
order.
satisfy us on the reason why you say that is bad. Thereafter, we'll go for jurisdiction.
No, but first jurisdiction issue has to be settled.
We will not, on the basis of a person in a PIL, we will not do that. PIL is public interest. You show how the public interest is affected because of this.
That para 16, my lord, has already seen. Let me justify this way, my lord. That hospital, Chaglagam, first administrative circle, that is 100 kilometer away from.
We are not concerned. We are concerned with the functioning of the hospital. If the hospital continues to function without the DMO office, we will not entertain. Or show us that these doctors, DMOs, they are also doctors in the hospital. They also go there and treat patients. You have two services, hospital services.
My lord,
different,
the
No?
program officer includes
is
DMO,
different.
my lord, that is different, my lord.
And this is different.
Yes, my lord.
It's like health A, health B.
Yes, my lord.
No, my lord, factually not correct.
Show material, Mr. Tara.
But factually not correct in the sense because a trained doctor always performs two duties in Arunachal. One, administrative capacity, he functions as a district medical officer and simultaneously functions as a doctor who.
In the
as a-
hospital?
In the hospital. GDM.
Show that.
No, that I think still has a.
No, you will have to show that.
No, I don't have this particular document.
Where is your statement to that effect? There is no statement to that effect in the PIL.
No, para 16. We read together. my lord, a while ago.
It's only guidance and monitoring. It's
Yes.
not that they are going there and doing. They will have no role in that hospital.
No, my lord, that is very categorical, my lord. My lord, kindly see. there has to be an approach of vice versa in this case. Because administrative as well as the trained medical doctors will have.
They don't merge. They are like two rail lines. Both are required, but they don't merge into each other. Cannot, because that aspect
there-
is totally, that's
My lord will
administrative.
see their initial appointment is a general medical GDMO.
GDMO, show me
General
that
duty-
GDMO
There
is
is a guy-
working in the hospital.
Let him, sir, my lord, let him bring the guy.
First,
I'll file the affidavit.
raise that issue. Thereafter, we'll answer.
No.
Yeah, we'll close it. You come back with better materials.
The repository documents which they are having, it is with them.
You raise a grievance to that effect. You have not raised a plea to that effect.
That I respectfully agree. I cannot quarrel also on this point.
You need not, it's not quarrel, it's deliberation.
No, when I cannot sustain the argument and the mind that is falling from their lords, then I cannot advance my argument.
Only, Mr.
Except or otherwise, you know, that Hassan Ara Kutan judgment.
We
From
got
the
it.
basis where the PIL,
No.
the
The PIL is public interest.
correct, my lord.
Your interest here is that if this hospital, this wing, DMO office is shifted out, the hospital would suffer. So for that, you will have to show that the doctors here are also doctors here.
Correct.
Then if this goes away, there will be a
Ma-
fall in the doctors.
To this, my lord, I have one small answer. There is Arunachal Pradesh Health Services rules. That rule, my lord, I have not annexed. In another matter, I am handling, my lord. There's a Dr. Dubam Bagra case, which my brother Tapin also,
Just show
is
that.
also. But this is not available with me.
You take,
Anything, my lord, right from the entry as a general duty medical officer, then up to the director, the initial appointment is GDM only. From there, my lord, the classification is time-bound scale, then senior grade scale is there, then specialist cadre is there. So first, they are doctors. They are not administrative officers, my lord. My lord, example, my lord, the parimateria thing is, or that district medical officer is also a medical officer, but he looks after certain administrative matters. He is designated as a district medical officer. District medical officer and senior medical officers are same, one and the same. So क्या बोलते हैं? Hey.
This is their district DMO, district medical officer, their administrative grade. Madam. They are by way of promotion on length of service, they are given promotion to the administrative post, madam. That is their care, madam. It is not a case that the DMO, they are also serving. This is not, they are an administrative capacity. They are in charge, discharge.
you have made many submissions, but you have not dealt in your reply in that line also.
My lord, that is why, my lord,
Whereas he has said,
my lord, only the query we have filed with only put forward.
My lord, I will come back with the rules tomorrow. Arunachal Pradesh health
no, you-
rules.
Mr. Tara, only thing you show us that by shifting this hospital, the strength of the doctors, no, shifting of the DMO office, the strength of the doctors working in the hospital will be reduced. That much only.
That is one. Well, that second aspect, my lord, kindly try to appreciate my contention also, because shifting of the office.
We will come to that.
Well, see,
That is jurisdiction. Will come.
shifting of the office, my lord, requires a policy decision, and the deputy commissioner definitely do not have the power, my lord, to transfer it
We-
unless or until it is not by means of a policy decision.
We will.
Now, my lord is aware, policy decision, Read court will not interfere,
Mr.
but the
Tara,
decision-making process itself
we
we
will
can.
come into that. There is no issue. But first, this is a public interest litigation. Satisfy us on the public interest.
That's why, brother, the satisfaction I have referred to Hussain Ara Kutan judgment, Lord. Then
Actually,
that I'll come also. Then BP single judgment is there, my lord.
you come.
No,
Close.
finally, my lord will boil down to this Malwari versus Medicine, 1863 trans page
We
127.
will
Lord,
go
paragraph
where-
9 of that judgment is there.
We will go where you want us to go, but
Yes.
first establish your public interest. That the hospital will suffer. That's the only area we are concerned. Show that.
I agree to that, my lord.
Show that. When?
Give me 1 week time.
On a query made by this court to the learned counsel for the petitioner, Mr. T.T. Tara, as to in what manner the functioning of the hospital at Hailuing, Kaliko Pul Memorial District Hospital at Kaliko at Hailuing would be affected in the event the district office of the district medical officer is shifted out from that place to Hawaii. Also, it is the contention of Mr. Tara, learned counsel for the petitioner, that the doctors who are working in the establishment of the district medical officers also are required to discharge duties as doctors treating patients in the hospital. And accordingly, he submits that he be granted a week's time to bring on record material to establish his aforesaid contention. Also, accordingly, Mr. Tara is granted a week's time to file an additional affidavit to bring on record materials in support of his above noted stand. Full stop. The learned standing counsel of the health department shall also apprise this court on the next day as to the manner in which the doctors are of the government service are allotted between hospitals and for administrative works. Full stop. The rules, if any, governing such service shall also be placed on record.
Services. This there
List this matter again after
after
a
week.
week on a date to be fixed by the registrar.
Grateful.
May I please your lordships?
It will be.
May I please your lordship? May I please your lordship? My
Yes,
lord, am
yes.
I audible?
Yes. Yes.
Yeah, my
Audible.
lord. In this case, I would like to seek some time, lordship, and I would like to come down and argue the matter before the honorable court. So I need some accommodation for the day. Sorry, and I am apologizing for not informing well in advance. My lord, will it be possible on 23rd of April, lordships?
Heard MS D. Ghosh appearing for the appellant through video conferencing. Heard MS G. Tado, the learned additional PP for the state of Arunachal Pradesh. You are also appearing.
I'm the LSC for the victim,
Heard MS
SV Tara.
has been appearing for the host is allowed. When do you want it?
23rd of April, lordship. 23rd of April, lordship.
12,
23rd.
23rd of April,
Yes,
April.
lordship. Yes, lordship. After Bihu.
28th,
23rd.
after Bihu, 28th, 23rd, list on
Lordship.
23rd April for hearing. 23rd April for
Obliged.
hearing.
Most obliged.
Deeply obliged, lordships.
Okay. I will list it for hearing again because some points are to be cleared. Item number 1, heard Mr. R. Sonar. AP for the respondent. Heard Mr.
representing petitioner.
K. Tagyun.
K. Tagyan.
K. Tagyan.
Yes.
Heard Mr. K. Tagyan appearing for the petitioner. Heard Mr. R. Sonar appearing for the respondent. List this matter again for hearing. When? When do you want it? Next week?
Next week.
21. List the matter on 21 again for hearing. Item number 2. Item number 2.
Oblige your lordship.
This is a bail application.
Yes, Your Honor. Your Honor, I'm appearing on behalf of the conducting counsel, Mr. T. Laji. Your Honor, this is a bail application under section 439 of the CRPC. Praying for,
Since when he was arrested?
he was arrested on 10/8/2023. 10/8/2023, and it has
Okay,
been,
Lakshmi, diary will be required. Case diary. Oh, the
Your Lordship,
trial is going on.
Your Lordship,
The Electoral
The-
5 page 15, Lordship, it is reflected here, Lordship, in paragraph 4, Lordship.
The trial is going on.
Lordship. There are 34 to 24 the CC will be considered, Lordship. The case is fixed for CC on 34/24. In that case, Lordship, LCR may be called for, Lordship. Scan copy of the
Scan
LCR,
copy of the LCA.
Lordship.
Your Lordship, the CC was listed on the March 1 of the March 1. And on that particular date, on that particular week, the learned session judge went for training, Your Lordship. And the date of the CC has been pushed to the April 30th of the April. So on 7th of the March, bail hearing was there, final bail hearing was there. And the learned session judge said that she is not inclined to grant bail before the CC. But Your Honor, the question is this, without any fault of the accused, which was supposed to happen in March 1, it has been pushed in April 30, Your Honor.
Okay,
How we
alright,
can stay for
All right.
60 more days in
I-
the
I
judicial
will
custody?
put the LCA.
Yes, sir.
LCA will be required.
Yes.
Hard Mr. What is your name?
Dean May, Your Honor.
Tilime.
Yes, Your Honor.
Preparing for the petitioner.
Yes, my lord.
Hard MS Lakshmi, the learned additional people for the state of Arunachal Pradesh.
If my lord may, so date may be given, since he is in 216 days.
Call for the scan copy of the LCA. When it will come?
Lordship, after 2 weeks, Lordship.
After 2 weeks.
Lordship.
Your Lordship, if 1 week is there.
Okay.
Okay, Lordship, after 1 week. Lord.
At least after 1 week. After receipt of the LCA.
Like that.
Yes, Mr. Sunar.
My lord, here is the, my lord, this, only one section, my lord, 406, my lord.
That's it.
This is only non-bailable, all are bailable case, my lord. My lord, here is the case, my lord, this petitioner is the, my lord, assistant command in IRB and presently is serving, my lord. What happened, my lord, during 2018, when he was serving as the officer in charge of the Doimik police station, my lord. Then, my lord, an FIR was filed by the, my lord, petitioner, who is the next item, my lord. With the petitioner, he filed one complaint saying that he was cheated by the accused, who is the complainant in this case. So, being a OC, my lord, when any cases come, my lord, my duty is to register the case, my lord. And I endorse the matter to IO. Then, during the course of investigation, the IO and other official, they went to Sejosa police station. Already there was this excavator machine, my lord, that was already seized by the Sejosa in connection with other case. So that has a connection with the present case, Doimik police case. Then, my lord, the IO, he went there and he seized that excavator. He brought back to Doimik. Is still present in the Doimik police station. Now this complainant, he lodges a complaint against the complainant of that case as well as other police personnel, saying that we have hatched conspiracy and therefore that excavator was seized from the Sejosa police station without the permission of the court, my lord. On that basis, my lord, the inquiry was conducted. Thereafter, my lord, that inquiry has been treated as a FIR. Now, very interesting, my lord. Now the question comes, my lord, how this section is, whether there is, my lord, whether this section can be, my lord, attracted at all or not, my lord, because, my lord, FIR, my lord, doesn't disclose, my lord. My lord, may I take you the, my lord, this FIR first, my lord.
Page 23.
Page 22, My lord, this is the page 20. My lord, original FIR, my lord will find, my lord, this annexure 3, page 14.
Page 14.
This is on the basis of this inquiry was conducted.
Hmm. Okay.
My lord.
Hmm.
FIR against ASI Nirinama Inspector Bangjang Tangjang, my lord. I am the petitioner here, my lord.
Hmm.
Bangjang Tangjang. Both belonging to Duimuk Police Station, Inspector P. Galati Sijur and Tagung Niri for criminal conspiracy, forgery, fraud, cheating, so and so, my lord. My lord, should I read entire contents, my lord?
Hmm.
Entire contents of that.
Oh, yes.
My lord. ASI Niri Rama posted a re-siege and remove L&T Komatsu excavator belonging to my mother Bimla Devi Agarwal from Sejosa Police Station, Naharlagan, which was recovered and lying at Sejosa Police Colonel Sejosa lodged by me. The uniformed criminal has claimed to have received the above said excavator as being required under Duimuk Police Station. Although upon reading the said FIR, no such prayer at all seemed to have been made therein to recover any excavator at all whatsoever. The Duimuk police case number was a false, fake, fraudulent, and frivolous affair which has now been disposed of as FIR by SIT or Natural Police so and so. The delinquent officer ASI Narama neither had any production warrant nor any court orders whatsoever, allowing him to remove and take away the LNC Komatsu so and so from the custody. So it was the above said excavator was a court property and transported stages of were code or made the act improper, illegal, unlawful, and punishable under them. Inspector P. Kalita of so and so, an investigation of is an equal partner in the criminal conspiracy as he handed over the above mentioned excavator, which was a court property to uniform criminal ASI Niri Nama without any production wherein court order in utter contempt, breach, defiance of law, being hand in gloves with other criminals in the said act of crime, acting mala fide, malicious, and criminal intention. It is pertinent to here state that siege excavator is a huge machine weighing around so and so, and equally huge in dimension and size, and as such cannot be carried and removed in the vehicles that Arunachal Pradesh police possesses, and thus it becomes equally important to investigate as how the uniform criminal ASI Niri Rama carried and transported the above excavator from Sejusa police station and who bore the expenses of such illegal, unlawful, and improper act of transportation. The delinquent officer, and after removing the excavator from Sejusa, neither took it to Duimuk police nor produced the seizure before the magistrate in utter defiance of law but misappropriated it. FIR so and so has now been transferred to Mariang police citing the territorial jurisdiction, and FIR has now been registered so and so and so. A status report forwarded by the investigation officer Mariang so and so claimed that excavator has been misappropriated after being removed from Sejosa police, as the status report claims that the re-siege a removed excavator is not available at Duimuk police station upon inspection. Since Inspector Bangjam, the officer in charge of had ordered ASI Niri Rama to recover, remove, and transport the excavator from Sejosa in utter breach of law, as he was the mastermind who had hatched the conspiracy in connivance with Inspector P. Kalita, ASI Niri Rama, and history sitter Tagungiri. The criminal conspiracy began by lodging a false, fake, fraudulent, and frivolous FIR by history sitter and so and so. The said criminal conspiracy was further emboldened by uniformed criminal Inspector Bangjang Tangjang, OC Duimuk, who without application of mine and preliminary investigation registered FIR number so and so, so and so and so. The said criminal conspiracy could never have succeeded without the above connivance of Inspector K. Alita, so and so, who handed over the excavator to uniform criminal ASI Niri Rama for removal and transportation without any production warrant, so and so. Excavator lying at Sejusa was recovered and seized under FIR so lodged by me and was a court property. Had inspector acted in accordance with law and denied handover, removal, and transportation of the already seized excavator, in the absence of court order lying his custody from Sejosa, discharging his legal duties to uniform criminal SI in the absence of court order, the criminal conspiracy could never have succeeded. However, Inspector P. Kalita also acted otherwise in utter disregard and lawful improper way, since he is part of the criminal conspiracy. Lastly, the uniform so and so removed, misappropriated the excavator being the active participant in the criminal conspiracy. The above acts of uniform criminal ASI Nara Inspector so and so are criminal cognizable in nature, this warranting the lodging of FIR are requested to register a fit and proper against all the affairs so and so under appropriate section of law as per established for proper action and prompt investigation without further loss of time. I sincerely hope that no further time would be wasted in recovering the excavator so and so. It is pertinent to state here that the history seeker and habitual offender Tagunara Niri had entered into an agreement with my brother Bimla Devi at Dibrugarh, Assam to take 4 excavators belonging to her on hire, but neither paid any hire for their use nor returned them back to the owner even after instead misappropriated them, and FIR number Dibrugarh is pending on such account since life 5 years awaiting investigation and disposal. The excavator mentioned herein is one of those excavators as mentioned therein Dibrugarh police case number so and so. The present FIR is regarding the illegal handover, removal and misappropriation of already recovered and seized excavator under so and so at the hands of uniform criminal, namely Niri Rama Bangjang Tangjang P. Kalita in active connivance with so and so. A fresh cause of action has arisen out of account misappropriation at the hands of uniform criminal in active connivance with hence the FIRs. The Honorable Supreme Court of India in its landmark judgment in the case of Lalitya has directed the police to forward registered as soon as criminal cognizance is reported to the police authority, and I sincerely hope that your good office will act in true spirit with the direction of the apex court. You are humbly requested to register a feed and proper FIR so and so. Now, my lord.
Okay, why are you apprehending arrest?
My lord, my lord, notice has been issued by the case has been registered against me. My lord, this FIR on the basis of FIR inquiry has been conducted. That inquiry has been registered as a FIR. My lord, kindly see the inquiry report, relevant portion.
No, okay, just a minute.
My lord, this morning I had a telephonic conversation with the concerned IO. And I have been told that, my lord, a notice under 41A has been issued and they have been cooperating with the investigating authority. There's no apprehension at all. A notice is in page number 26 of the.
Heard Mr. J. Sering, the learned public prosecutor for the state of Arunachal Pradesh, call for the case diary. Fair. It is hereby directed that in the event action it, what is the case number? Doimuk Police Station.
No, my lord, this is a CB case number, my lord. CB Police Station case number 02 2020.
CBPS case number 02 of 2023. The petitioner Banghang, Banghang Tangjang shall be released on bail of rupees 20,000 with a surety of like amount to the satisfaction of the arresting authority. List again on
27.
On 27 March.
And my lord, another this serial number, my lord, this
Item number? Item number 4. It is also same.
Same, my lord. Here, my lord, I was the complainant. That's why.
The same order.
Yes, ma'am.
Petitioner naam to change kariye.
No case otherwise, my lord.
CB case number is same. And the name of the petitioner is Tagung Neri on 27. Interim bail granted.
My lord. Much over.
Five Sona is there. The criminal evidence petition.
My lord. My lord.
May I please, my lord? My lord, leading counsel for the respondent is Lakes in court too, my lord.
Report number 2.
Yes, my lord.
It is for admission here. It should go for hearing.
Therefore, my
parties
lord,
are present.
may I humbly pray, my lord, it may be admitted, my lord, and then we may fix for hearing, my lord.
It should go for hearing.
My lord.
What? My lord, if it is today admitted, my lord, then my prayer, because what is the urgency in this case, my lord? Because if the trial is concluded, because basically here, my lord, I am challenging the legality of the order by which the main accused has been granted pardon and made approver, my lord, without following the principal object for granting of the, my lord, this pardon, my lord.
We will go for hearing.
So that's my lord.
My lord.
This matter may be admitted today and my lord may be fixed for hearing, my lord.
Both sides are duly represented. The matter is admitted for hearing. List on when?
My lord, I pray, my lord, this matter may kindly be listed on, my lord, April 2nd, my lord.
2nd of April
My lord.
for hearing.
Obliged, my lord.
I'm appearing on behalf of Mr. S.K. Dury. I'm appearing on behalf of for the petitioner, Your Honor, on behalf of Mr. S.K. Dury. I've been instructed to withdraw this petition because they're not. I've been instructed to withdraw this petition. Petitioner is not going to
You want to
pursue it
withdraw
further.
this petition?
Yes, Your Honor.
RMS T.Y. Bhutia, appearing for the petitioner. Mr. T.A. the learned additional public prosecutor for the state of Arunachal Pradesh. MS Bhutia submits that she had instructions to withdraw this criminal petition under section 482 of the CRPC. Full stop. After hearing both sides, the prayer of MS Bhutia is allowed. The criminal petition stands disposed of on withdrawal. Are there any interim order pending?
No interim order.
Disposed of on withdrawal.
Deeply obliged.
My lord, in this case, my lord, pass the order, my lord, made by presence of the parties, because my lord, 487 seeking quashing, they all are, my lord, related. Even mother, biological mother has been made as one of the accused, and other two lady are her maternal uncle. Petitioner number 1 and 2 and 3 are the husband of the maternal uncle.
Okay.
So, my lord, as desired by this honorable, because the parties are present, my lord, before this honorable. So this is a case, my lord, they have this petitioner number 1 and 2, they both got married, my lord. Now staying together and entirely looked after by the petitioner number 2, my lord. Now within family they all are.
Okay.
So that's why, my lord, seeking quashment, because, my lord, ultimately.
Okay, what do you say, saying?
See, we have settled the matter.
Okay, then it is passed.
My lord. Much.
Number 9.
This also, my lord, application under section 482, my lord. My lord, contents of the FIR, my lord, we find allegation here. Now the lady is saying, the company is saying, my lord, I have been in relationship openly living as husband and wife.
My lord, before my elder brother starts, my lord, in this case, already charge sheeted, trial has already been begun. They have challenged the FIR here. So I don't know.
Even a charge sheet has been included, my lord. And, my lord, law is now very clear. It's recent judgment of the apex court also said, my lord. Even, my lord, subsequent filing of charge sheet do not bar the court from considering the quashing of the FIR. If the FIR doesn't disclose any case, my lord, this is good. But here in this case, my lord, I have enclosed additional charge sheet also. Charge sheet also has been filed, my lord, by way of additional. My lord, I will come to those things, my lord. Before that,
My lord, I have not been furnished with the additional charge sheet filed by him, and then cognizance already been taken.
You have not received a copy?
No, I have not received. I am for the complainant.
Yeah.
Respondent number 2.
Wait, give him a copy, then hearing will be done.
And cognizance is also.
well,
been
that
taken.
is cannot be the bar. My learned friend is not understanding.
I understand, you just give him a copy, after the hearing will be done.
Next date may be.
Heard Mr. R. Sonar appearing for the petitioner. Heard Mr. J. Sering, the learned public prosecutor for the state of Arunachal Pradesh. Heard Mr.
R. Koyu.
R. Koyu appearing for the respondent number 2. Mr. Koyu submits that he has not yet received the copy of the additional affidavit filed by Mr. Sonar. Therefore, the petitioner is directed to provide one copy of the additional affidavit to Mr. Koyu. List again on.
Lordship, my cognizance is already.
Washing can go. When?
My lord, April 3rd, my lord.
On 3rd April.
May I submit, Lordship?
Hmm.
Lordship, this is instant petition is for setting aside and causing of charge sheet dated 26/6/2020, Lordship. The FIR is at page 19, Lordship. May I read, Lordship?
Where is the FIR?
Page 19, Lordship.
20.
19.
19.
Yes.
Yes.
It is to inform you that I turned 17 in so and I was raped last year. That is at the age of 16 by so and so in his official quarter at Itanagar, where he called me in for some work, and as we were never, I went to his quarter in good faith, but taking the advantage of the situation, he forcefully raped me without my consent and threatened me not to disclose the incident to any other person. As a result, I got pregnant and delivered a daughter on 28 May 2019. After delivery, I tried to stay at his quarter, but he started to torture me and threatened me to kill with his revolver. Now he threw me out of his quarter with 1-month-old daughter. So accordingly, on the basis of this FIR, Lordship, on the basis of this FIR, Lordship, charge sheet dated 26/6/2020. Lordship, initially this case was registered under under section 376(2)(I) of IPC, read with section 6 of POCSO Act, Lordship. Now, during the course of trial, ossification test was done, Lordship. Ossification test was done, and after the ossification test was conducted, she was found to be aged 22-24 during the commission of the alleged offense, Lordship. Now, that is reflected in page 38, Lordship, Annex 3, order dated 30/6/2022. May I read the relevant para, Lordship? In accordance with first, second, third para, Lordship, in accordance with this case, White order dated so, Chief Medical Superintendent of TRIMS have submitted ossification test report stating that victim girl in the present case was found to be aged about 20 to 24 years as on date of her examination held on
When she was examined?
It was on 17/5/2022.
And 22, she will be more than 18 years old, but occurrence took place in the year 2018.
Lordship, March 18 years, Lordship. Now, and accordingly, this section 6 of the POCSO Act was serious. So, and then the case was lodged just because the parents were not in agreement with the relationship.
Okay,
Now,
okay, on some other day.
Lordship, they have settled the matter and they have approached
It will be
this.
taken up on some other day. List this matter on 27 March.
Similar matter, Lordship, like
Who is
previous.
the next one? Next.
DP only. May,
Yes.
my lord. My lord, this is also 482 matter, my lord, for passing of criminal proceeding, my lord, on the basis of mutual settlement, my lord. My lord, offense involved here is 354 IPC, read with section 8 of POXCO Act, my lord.
Hmm.
My lord, though, my lord,
Where
POXCO,
is the FIR?
my lord, FIR is phase number 24, my lord,
20?
24. May I read, my lord? Phase number 24.
Yes.
FIR against one so and so. With pertaining to above cited subject, we have the honor to inform you that one so and so, TGT English Secondary Vidyalaya, Daporjo has molested many child of the Kendra Vidyalaya School, Daporjo, as your names are mentioned below. Total, my lord, Alice victim are total 9 in numbers, my lord. Sir, the health of child is not normal as.
Where
there-
is the statement of the victim
My lord,
under section 164?
yes, my lord. My lord. My lord. My lord, may come page number 30. 38, my lord.
38.
My lord, yes. This is one of the statement, my lord.
The 161 statement.
One statement. My lord, since all the statement are almost similar, my lord. So may I read this statement, my lord? My lord,
164 statement is there or not?
164.
164?
Yes, my lord, 164 is also recorded, my
Where
lord.
is the 164 statement?
164, my lord, I have not annexed, my lord.
You annex the 164 statement.
164, I think that is in the records, my lord.
You annex it. You annex the statement only.
My lord, that
Mr.
is, and in LCR is already there, my lord. LCR is already.
LCR is not required. You annex the 164 statement only. Hard Mr.
El Kurdu, my lord.
Yeah. APA for the petitioner, Hard Mr. J. Sharing, the learned public prosecutor for the state of Arunachal Pradesh. The petitioner is directed to annex. The petitioner is directed to put on record the statement of the girl, the statement of the victim girl that was recorded under section 164 CRPC by filing an additional affidavit. Least after 2 weeks.
My lord, can you fix on Friday, my lord?
Hmm?
Friday, my lord, Friday.
Idea not possible. Next week. Next week.
God bless, my lord.
By additional affidavit, 164 statement you file it. Next week.
God bless me.
Please, my lords.
Yes.
Lords, the petitioner is on interim bail granted on 21st of December 2023, my lords. It is listed for confirmation of interim bail, my lords.
You have appeared before the IO. You appeared before the IO.
We've appeared before the IM, lords.
You have
We've
appeared before the IO.
taken the bail, my lords. Those are also submitted with an affidavit filed on 29th of January 2024. Now, the last 2-3 occasions, the case diary has been called for, but that has not been.
Is they not received? Mr. Kato?
My lord.
Your Lordship, the matter has been charge sheeted and the entire record is before the magistrate.
Oh, charge-sheeted.
Yes.
You call for the LCR then? I'll call for the LCR. Hard Mr.
Lords, A. Sahani.
A.
Sahani.
Sahni.
Sahni. Lords, if I may just submit, my lords. Lords, if the charge sheet has been filed, my lords, will appear as and when cognizance is taken by the magistrate, my lords. This order may be made absolute. We've already complied with the conditions, my lords.
No, I'll call the LCR. Sani appearing for the petitioner. Hard Mr. Hard MST Genie, the learned additional PP for the state of Arunachal Pradesh. Hard Mr. M. Kato is appearing
My lord.
for
Report complaint.
the complaint.
Respondent number 2.
Respondent number 2. MS Genie submits that in this case, police has filed a charge sheet. Therefore, call for a scanned copy of the LCR.
Okay.
List again after 2 weeks.
Yes, Lord.
I can give you a date.
Milords, may I request for the dates? I could be coming from outside.
On interim. You enjoy
On
it.
interim.
List on 1st of April. Is it okay for you?
Milords, may I request second or third, whichever is convenient.
Second or third? Third
Please,
April.
please.
Till then, the interim order passed will continue.
My lords, and one more indulgence, if I may just submit, my lords. There's an order of 19th of February and 28th of February, my lords, wherein I've been granted exemption to appear before the my lords CJM. So, my lords, every time this matter is listed here for compliance, the matter is also listed before CJM. And my lords, I had to appear there. On 19th of February, my lords, exemption has been granted and extended. We did the order of 28th of February. Lords, I'm only seeking the indulgence may be continued for today's date and next date as well, my lords.
Your Lordship, if I may, in that ground, Your Lordship, earlier the charge sheet was not filed, Your Lordship. Once Your Lordship is well aware that once the charge sheet is filed, Your Lordship, their appearance is necessary, Your Lordship.
Okay, all right.
No, the cognizance has not been taken. It may be in file, but as and when cognizance is taken, summons is
What is
issued.
the date of order?
Was 19th of February, my lords, the first order.
February 2024.
And my lords, that was extended on 28th of February as well, my lords.
Till then, the petitioner is not required to appear before the trial court.
Please, deeply obliged, my lords. Deeply obliged.
Deeply obliged, madam.
Item number 13.
May I please, my lord?
Yes.
This is my lord application.
Bail application.
Bail
CD received or not?
Your Lordship, LCR was called for in this
Or
matter.
LCR was called for.
LCR was called for.
LCR.
The victim examined or not?
No. 13.
In the trial court?
Trial not yet commenced, my lord.
So that is the LCR. The victim not yet examined.
No, it's not.
Trial not yet commenced, my lord.
Let the victim be examined first.
Yes, Your Lordship.
Then after that you come again.
My lord, difficulties is that, my lord, since the PO is on leave, long leave.
Still then you have to wait, because this is a serious offense.
Yes, Your Lordship.
Lord's
Even
request-
otherwise, the case has been, any case coming to the special bench has been endorsed, Your
My
Lordship.
lord,
At least for the-
otherwise,
At least for, with regard to bail and other applications, Your Lordship.
otherwise, my lord, kindly peruse the charge sheet and the FIR, whether the case is made out or not.
Anyway, the victim has to be examined. The process should continue.
Yes, sir.
There is a specific procedure for trial. The trial should continue. At least the victim and the complainant are to be examined first.
Yes, sir.
Tomorrow, my lord, if this accused is not found guilty, today, as on today, my lord, 149 days.
That is not important. He was arrested by police.
In fact,
Of
the
course.
other.
There cannot be any question of personal liberty.
Yes, Your Lordship. In fact, the other, even other ground, Your Lordship, is that victim is his sister-in-law, Your
In
Lordship.
that case,
The bail
lordship,
application has been filed by
since
the sister of
PO is on
the
leave,
victim.
so
He will come again. He is not on permanent leave. He is on temporary leave. Trial will, let the trial continue. Heard Mr. T. Lampung.
Ketama.
Okay,
In that
come.
case, my lord, may I pray
Hmm.
that I may be allowed to withdraw this bail application?
Okay. Heard Mr. K. Tama,
My lord.
APA for the petitioner. Heard MST Jini, the learned additional PP for the state of Arunachal Pradesh. Mr. Tama submits that he has instructions
My lord.
to withdraw this bail application. Accordingly, the bail application stands disposed of on withdrawal.
Highly obliged.
Deeply.
Item number 14.
My lord, liberty will be always there.
In
Liberty.
criminal matters, liberty is not required. In civil matters, liberty is required.
Highly obliged.
Item number 14. None appears for the petitioner on call. Heard Mr. G. Tadov, the learned additional public prosecutor for the state of Arunachal Pradesh. Since none appears for the petitioner on call, the matter is adjourned today, list next week.
Your CD may be able to return.
CD, you want to return?
Yes,
The CD shall be returned for the time being, for now.
complex.
Item number 15.
Yes,
My lord, CD was called, it was fixed on 7 and then again it is posted today. Lord.
NDPS Act.
Yes. Your lordship, the on the due today is the 61 period of 60 days already been completed yesterday, your lordship. Also, in that case, the
Is it a 60-day case?
yes,
Yes.
21B, your lordship, intermediate
21B.
quantity.
Okay then. Hard Mr.
El Tatam, my lord.
and Tada,
Tatam.
Tapak, appearing
Tatam,
for the
Tatam, my lord. Tatam.
Takam, appearing for the petitioner. Hard MST G Nidhi learned additional preview for a state of Arunachal Pradesh. Para. This is an application under section 439 of the CRPC. In respect of Naharlagun PS case number 05 of 2024. Under section 21, within bracket B, small b, stroke 27 of the NDPS Act. Para. MSNE submits that the maximum period of detention, MSNE submits that the statutory period of detention is 60 days in this case, and today is the 61st day. Para. Considering the submission made by MSNE, this court is of the opinion that the petitioner is entitled to default bail. Accordingly, his bail application is allowed. The petitioner, what is the name?
Bini Sora.
Miss Bini Soda.
Yes, my lord.
Sorry. Sora shall be released on bail.
No, your lordship, the accused name is Duto Sora.
Huh?
Duto Sora.
Duto Sora.
Is accused, my lord.
Sri Duto Sora shall be released on bail. In of rupees 20,000, 25,000, with the surety of like amount to the satisfaction of the learned special judge.
Your lordship, I also may put on other conditions, your lordship, since the investigation is still on, your lordship.
Oh,
If he is without jurisdiction, he does not go out of the court, your lordship, place, your lordship.
It is further directed that without the permission of the investigating officer, the petitioner Duto Sora shall not leave the jurisdiction of the said police station.
Nor influence the witnesses, your lordship, if any.
He is also directed not to influence any other witnesses of this case.
And lastly, your lordship, if he cooperates and is present whenever the IO.
He shall cooperate with the police investigating officer as and when called for. The bail application stands disposal.
Much obliged.
Your lordship, I on behalf of respondent number 1.
But the applicant, who filed this IA?
The applicant, Your Honor, the appellant. Absent.
None appears for the applicant on call.
Your Honor, the service is awaited on behalf of respondent number 2 and 3, Your Lordship.
But none is appeared today. None appears for the applicant on call. Hard MS
M. Likha.
and Likha appearing for the respondent number 1.
Yes, Your Honor.
Respondent number 1. Since none appears for the applicant on call, the matter is adjourned today, least after 2 weeks.
Okay.
This is for orders,
My lord, this matter become infectious, my lord.
is it?
Basically, my lord, by this revision, the petitioners have assailed the appeal that was taken cognizance by the,
You were appearing for the first time today.
no, my lord. earlier also I have appeared, and there was interim order.
Why it is listed for orders today? You are appearing for both the respondents.
No,
Uh,
I'm appearing for respondent number 1.
Your court report may be called for
Ah.
in this case.
Huh?
Your court report,
Ah.
because they have made an appeal. They made an appeal before the Arunachal Pradesh Gaunbura Puri Welfare Association.
Oh.
So the report may be called for. There is
That will be-
yearly appeal.
That will be
number
not necessary, my lord.
To the-
May I briefly tell the fact, my lord?
Hmm.
Actually, what happened, my lord? The first village authority
Hmm.
decided a money case
Hmm.
in favor of the petitioner.
Hmm.
Thereafter, what we have done,
Hmm.
I am for respondent number 2.
Hmm.
I have filed appeal before the apex authority, village authority.
Hmm.
And when I have filed that appeal,
Hmm.
they have put to challenge the notice that was issued by the appellate village authority. And thereafter, this honorable court was stayed, suspended the proceeding. Later on, I have entered, and then I have filed one IA also.
Hmm.
And that IA was heard and considered. Thereafter, that interim order that was vacated. Basically, their contention is that all Arunachal Pradesh Gamburi Association is not a appellate authority.
Hmm.
That was the contention.
Now, who filed the appeal?
Appeal I have filed.
You have filed.
And in the meantime, what happened,
So
my lord?
what happened to the appeal?
Now appeal is disposed of, my lord. That's why I'm saying, when the interim order it was vacated,
Hmm.
proceeded, they have participated before the appellate court,
Hmm.
and finally this matter ends there also. This is the certified copy.
Now, what Mr. Patin was saying?
My submission here in the case is that the Kebang was held on 27/9/2021. In those days, if they feel it aggrieved, they can make an appeal. Since they have not filed, there was a delay of 600.
70
600.
Lordship, the order
612
passed in
days.
IA.
6 days. I prefer for execution of the decision. Then when the matter of the execution is pending before the deputy commissioner, as per the provision, they made an appeal by registering as appeal number 1 before the all Arunachal Pradesh Gaunbura and Gaunguri Welfare Association as the apex customary court. Now, my contention here in the case is that since 2021, the Arunachal 1945 regulation was amended in 2021. So Kebang was held in 2021. So it should be governed by the old law, but not by the amended law of 2023. They have made an appeal before the Nile Appeal 1, considering by taking the help of the amended 2023. And while as per today they have filed 25, they have filed without issuing us any notice, without knowledge of us, they have passed condemnation. Whereas, can they pass such condemnation without serving us any notice? Can they make stay order without hearing us the other party? And whether they are very much competent to hear the case. Appeal and execution is vast different. Appeal is different part and appeal is different part. We have already made an execution petition, and the matter was proceeded before a deputy commissioner. Can that execution proceeding can be stayed by the local union? If any stay is to be taken, they should take the stay order from the deputy commissioner court, not by the NILE. Deputy commissioner court is there above the court of the NILE. So whether a subordinate court can make any stay order against of the superior court proceeding, and they invoke the provisions of the amended 2023, whether the amended 2023 Act will apply, whether it has got retrospective provision to apply and force. First of all, we should ascertain that whether there was a retrospective. And if any amendment is made, it always made for the perspective, not a retrospective. Then they have not made any appeal against the CABA decision, which was passed on 27/9/2021. So I attend the finality. On the basis of attending the finality, I have gone for the execution. Now, in my prayer, I have already also prayed that end or pass such direction or order to produce the document regarding the constitution of all Arunachal Pradesh, Gaon Bura and Gaon Buri Welfare Association as the apex customary court of the all Arunachal Pradesh. Therefore, I need the constitution of that very association, whether they have been made an apex court of customary court. Therefore, the constitution of the all Arunachal Pradesh, Gaon Bura and Gaon Buri Welfare Association as the apex customary court of all Arunachal Pradesh be called for. We must know the constitution when they have been made an apex court. Who authorized them? Who appointed them? It is a non-existing forum. Therefore, the record of the document, entire document of the case record of appeal number 1 and the constitution of the all Arunachal Pradesh, Gaon Bura and Gaon Buri Welfare Association of the apex customary court be called for. For the purpose of today. I think that is the reason why it has been fixed for the orders.
Appeal number 01 of 2022.
01
of 22. 22.
Yes.
Appeal number 1 of 23.
23.
23.
23. Yes, annexure number 1 of page 16.
There is no such forum, Uncle.
There is no such forum. But how they made it? Just to challenge the execution proceeding filed by the petitioner.
Okay, I will call the
Yes.
records. Let the records come.
Yes.
My lord,
Yes.
our duty is to assist this honorable court, my lord. My lord may kindly peruse the order, because all this content which my senior brother has submitted, that was already taken note of by the coordinate bench of this honorable court. Kindly, just now I have given one judgment that was passed in IAC C-155 of 2023 may be seen, my lord. Here everything is clear, my lord. Paragraph 2 onwards. This is of dated 11/10/2023. The applicant has filed the instant application for vacation, modification, alteration of ex parte interim order dated 4/9/2023 passed by this court in his absence. It is contended that the order dated 49 was passed erroneously. The question of maintainability of the instance CRP number 45 so and so was misconstrued. It was held by the order dated 4920 that the all Gamburi welfare association prima facie does not have the jurisdiction of issuing the order of stay of execution proceeding pending before the SDO removed. It is submitted that if the order of stay is overturned, then the execution proceeding will be initiated and the present applicant will be greatly prejudiced as the present applicant has prima facie case that he is not liable to pay the amount as proclaimed by the opposite party. The learned senior counsel for the opposite party has raised serious objections stating that this court has not misconstrued the jurisdiction of the appellate authority and the order dated 4/9/2023 was correctly passed. It is submitted that the order impugned by the opposite party was passed on 27/9/2021. And consequently, the appellate authority is not the All Arunachal Pradesh Gambura and Gamburi Welfare Association. According to Arunachal Pradesh Civil Court Act 2021, the appellate authority is the district judge or the additional district judge. My lord, may be kindly taken note of this. 6. The learned counsel for the applicant has disagreed with the submission of the learned senior counsel for the opposite party as the Arunachal Pradesh Civil Court Act 2021 has been amended by government notification dated 14/11/2022, and after the amendment, subsection 4 of section 15 was inserted, which read as follows, as under. An appeal from the Bidal authority, if agreed to by the parties, shall lie before the Inter-Village Territorial Customary Court or Apex Customary Court by whatever name and called, which shall settle the case as per the local traditional customary laws under the provision of section 40 of Assam Frontier Regulation Act 1945. The learned senior counsel for the opposite party, Mr. So-and-so, has relied on the decision of the Honorable Supreme Court in so-and-so. It was held by the order dated 4/9/2023 that the All Arunachal Pradesh Gambura Gamburi Welfare Association prima facie does not have the jurisdiction of issuing the order of stay of execution proceeding pending before the SDO removed. It is submitted that if the order of stay is overturned, then the execution proceeding will be initiated and the present applicant will be greatly prejudiced. I am repeating, my lord. Next page. And others reported in so-and-so, wherein it has been observed that para 9, my lord, so-and-so. Kindly come to paragraph 8. The learned senior counsel for the opposite party, Mr. So-and-so, has also relied on the decision of the High Court of Judicature at Karnataka in so-and-so cases. So-and-so. Kindly come to para 9, my lord, at page 5. I have considered the submission of the learned counsel for the parties with circumspection. It is true that the order impugned was passed on 27/9/2021, but the appeal was filed before the All Arunachal Pradesh Gambura and Gamburi Welfare Association on 25/8/2023 and was registered as Nyale Appeal number 1 of 2023. That is after the amendment of the Arunachal Pradesh Civil Courts Act 2021 on 3/11/2022. 10. I have considered a submission that the applicant may be prejudiced if the opposite party proceed with the execution proceeding. It appears that as per Nyale Appeal 1/2023 was registered after the amendment of the Arunachal Pradesh Civil Court Act 2021 by notification dated 14/11/2022. The appeal prepared by the applicant was filed in the proper forum. The ratio of the decisions referred to by the learned senior counsel for the opposite party is not similar to the instant case. 11. In the wake of the foregoing discussion, it is thereby held that it would not be justified to interfere with the order dated 25/8/2023 passed by all Arunachal Pradesh Gambura and Gamburi Welfare Association in Nyale Appeal number 1/2020, wherein the execution proceeding pending before the SDO removal has been stayed and so cause notice was issued to the opposite party, namely the petitioner. 12. The order of stay against the stay of execution proceeding in Nyale Appeal number 1/2020 pending before the SDO removed, that is the order of stay dated 4/9/2023 passed by this court, is hereby vacated. So thereafter, subsequently, my lord, what happened? This petitioner himself, my lord, written a letter. Therefore, my lord, I am saying our duty is to assist this honorable court. This petitioner himself has written a letter to the appellate court, village authority, saying that there is no stay, so please conduct the trial immediately. This is pendency of this revision petition, my lord. Thereafter, trial was conducted and the final judgment. Just now, I have submitted the original copy to my lord. This is of dated 29 February 2024. Original life दिया था ना.
My lord, my submission is that there is
Now
no
matter
such
become
forum.
infructuous since already we have contested, dear my lord, and the matter is decided. And if they agree with this order, of course, there are some other forum where they can approach my lord. Therefore, I am saying, with utmost respect, the matter become infructuous. My lord. And he is representing the appellate court. Village.
Okay, well, let us go for a hearing of this matter. I will have to hear you again.
And record may be, my lord, record may be called for, because my submission is that there is no such forum. This forum is created by the respondent.
Okay, all right.
It is by coordinate bench already held. It is the
There is
appellate.
no such forum.
As per the amendment.
Learned Senior Counsel, Mr. M. Patin, assisted by M. Patin. Heard Mr.
K. Tama, my lord.
K. Tama.
For respondent number 2, my
For respondent number 2.
my lord.
Heard Mr.
T Kipa, Tanya Kipa.
T. Kipa. For
Yes.
respondent number 2.
3. Sorry.
Respondent number one.
Respondent number 1. Call for the records of this is appeal number 01 of 2023 from the office of the
All Arunachal Pradesh, Gambura and
All
Gamburi.
Arunachal Pradesh,
Arunachal Pradesh
Gaon Bura and
Gaon
Gaon Buri Welfare
Gaonburi Welfare Association. It is here.
Association.
It is here. The case number is here. Case number is here. This is Gaonbura Gaonburi Association.
And direction may also be given to produce the document and constitution. Constitution, how they have been become the apex court.
Who will produce the constitution?
No,
I will produce.
Okay.
Gaon Buri, Gaon Bura and Gaon Buri.
Learned counsel for the respondent number 1 submits that he will produce the constitution of the aforesaid Gaonbura Gaonburi Association, Welfare Association. List after 4 weeks.
Report of that appeal number 1. Along with the
Along with a status report regarding appeal number 01 of 2023. After 4 weeks.
highly honest.
Highly able.
Who is for 19?
I'm appearing for the respondent, sole respondent.
Sole respondent.
This matter we fixed on 3rd April.
3rd April. Both sides are duly represented. List on 3rd April.
Jobless.
Item number 20.
It is for orders. LCRs can copy received.
Lordship, it should settlement between the parties.
Okay. POXO.
No, Lordship. It has, Lordship. Initially, it was POXO, but it was later, after investigation, it was found that the victim is a major.
Victim is a male.
Victim is a major, Lordship. So POXO was removed, only 376 remains, Lordship. And Lordship, we are in a relationship at that point of time. We are still in a relationship at this point of time. But due to dispute at that point of time, the FIR was lodged, Lordship.
But
If my Lordship, if Lordship will read the 164 statement at page number 29, Lordship.
29.
Yes, Lordship. The victim has clarified why this case has come into being, Lordship. The circumstances were in page number 29, Lordship. Yes, 29, Lordship. The 164 statement before the learned CGM, Lordship.
Okay. It can be done.
Yes, Your Lordship, because since this case is totally based on the statement of the victim, and since they have settled the matter, and erstwhile there exists relationship between the parties. So, Your Lordship, in my humble understanding, Your Lordship, no purpose will serve by letting them looming in on the cloud of litigation. Yes, Your Lordship.
Cost.
Obliged, Your Lordship.
Hello, Sir, please.
Yes.
Here, the accused have been convicted under Sec 365 IPC, 376(1), 342, 323, and 506. Now, against of the judgment and order passed by the
in 376 also.
Now this is for suspension of the sentence passed by the district and session judge, UPIA, in session case number 40 of 2016. Now we have made an appeal, and the appeal has already been admitted as 04 AP 2024.
Earlier, before his conviction, whether he was on bail.
He was on bail. Now I'll come to the yes, he was on bail and come to the page 18. The Alex offense was committed on 25/7/2016. Now, he was during investigation period, he was released on bail. Date of filing of charge sheet is 22/8/2016. That means he was released on bail since 2016, and he has appeared in the court regularly till to the 25/1/2024, and he has not misused the liberty which was granted to him.
Okay, all right. Lakshmi, what do you want to say?
Lordship, as per the Lordship, I have record, the Lordship, I have go to the record, the answer has not come, Lordship, and today, Lordship, that IA maybe, Lordship, last occasion, Lordship. So, if Lordship have, then IA may be heard, Lordship, today.
Okay, heard the learned senior counsel, Mr. M. Partin, assisted by? Oh, you are also M. Partin?
M. Partin, my son.
Your son, yes. M. Partin, appearing for the applicant in the IA, huh? Heard MSH Lakshmi, the learned additional PP for the state of Arunachal Pradesh. Para. This is an application under section 389 of the CRPC, praying for suspension of sentence and for releasing the petitioner on bail. Para. On 25/01/2024, in respect of sessions case number 40 of 2016, within bracket YPA, the petitioner was convicted under sections 365, 376, within bracket 1, 342, 323, and under section 506 of the Indian Penal Code. Para. I have considered the submissions made with the learned counsels of both sides. The petitioner was on bail during the entire period of trial. He was remanded to custody at the time of delivery of judgment. Para. This court is of the opinion that the petitioner does not deserve to be detained in custody at this stage. Therefore, his bail application is allowed. The sentence awarded to him
10 years.
in respect of Sessions Case number 40 of 2016, YPA shall remain suspended. The petitioner, what is the name?
Nabum Tatang.
Uh,
Nabam
Nabam Tatang.
Tatang, accused.
The petitioner accused, Nabam Tatang, shall be released on bail for rupees 25,000 with a surety of like amount to the satisfaction of the learned Sessions Judge, UPA. Sessions Judge, UPA.
Sessions Judge.
The IAS disposal.
Lordship, then main petition maybe next day.
In the main appeal?
Main appeal in the till yet paper book has not been
Yes, Lordship.
prepared.
LCR not yet received. LCR not yet received. Heard the learned senior counsel, Mr. M. Partin, assisted by Mr. M. Partin. Heard MS H. Lakshmi, the learned additional PP for the state of Arunachal Pradesh. Office shall procure the LCR least after 4 weeks.
Like us.
May I please allot?
Yes.
This is a petition under section 482 of the Criminal Procedure Code, my lord, seeking quashing of the FIR number 175 of 2023. PS Papampare, my lord. This is an FIR which is registered under section 419, 420, 406, 34, 66C, 66D of the IT Act, my lord.
Okay, Mr. Counsel, I will take it up next week.
My lords may then have it in May if possible, my lords.
May.
May.
You can suggest, you come from outstation.
My lords.
You suggest one date.
My lords, either 22nd or 24th of May.
List this matter on 27th.
Your lordship, your lordship, in that case, we have received the case diary and your lordship, investigation is still in progress. So let the case diary be sent back, your lordship.
List this matter on 22nd May.
My lords.
The case diary shall be returned.
My lords, there are certain documents which were also supplied on the last date of hearing. My lords, they are the bank account statements of the petitioners, my lords, which show that the money is being received in their account and they are being sent to the company on the very same date. The only reason why the money was received in our account was that the complainant did not have a credit card, my lords. So, my lords, that bank account statement may also be made a part of the case diary, my lords.
When did you find
Your lordship, the case diary, whatever my learned brother is submitting regarding the bank statement, everything is the part of the case diary. And second part is, your lordship, this is the
those documents are in the case diary?
yes, your lordship. It's a part of the case diary, the bank statement.
Part of the case
And
diary.
it now the your lordship investigation is in progress. So in my humble understanding, your lordship, the accused has no right to be heard. And whatever is there, they can produce before the investigation authority
No, we have.
until or unless, your lordship, there is an exceptional circumstances. If there is a fundamental error from the part of the investigation authority. But however, your lordship,
The registration of FIR itself is an abuse of process of law when there is no wrongful gain on my part, my lords. There is no dishonest intention or fraudulent intention, and I'll show it from record, my lords.
Okay, on to 22nd May.
Great.
Yes, your lordship, the appearance of the respondent may be recorded, your lordship. They entered appearance today.
Then also heard Mr.
L. Kagum.
And paying for the respondent number 2.
Service complete.
2 and 3.
Yes.
Okay, all right.
Deeply obliged.
Item
number 27.
My lord,
You are for 27?
no, my lord. My lord, actually, I beg pardon, my lord, for item number 11, my lord. My lord, in item number 11, my lord has directed me to file additional affidavit, bringing records of 164 statement.
164
Yes, my lord. The next week, my lord. So, my lord, meantime, my lord, I have a small prayer for stay, my lord, say the proceeding, my lord.
First of all, you produce the 164 statement. On that day, it will be considered.
Till next date, my lord, only till next week, my lord. Since charge sheet is also yet to be framed, my lord.
All right. On the next day, it will be considered. Yes, who is for item number 27?
Yes, my lord.
Yes.
This is bill application under 439.
439.
Yes.
DPS.
Yes.
For
So-
this matter, case diary will be required.
So,
Without going to the case diary, bail application cannot be considered.
so, all the, co-accused are on bail.
And parity is not applicable in bail applications.
The fact and circumstances, based on the fact and circumstances, the applicant is not involved in this instance case. And all this seizure has been done from the co-accused.
Let the case diary come.
My lord, meanwhile, the interim may be granted because this alleged accused is languishing in.
This matter no entry. Heard Mr. T. Kipa, appearing for the petitioner, heard Mr. J. Sering, the learned public prosecutor for the state of Arunachal Pradesh. Call for the case diary when you come.
Charge sheet is also enclosed in this
28.
instance case.
28.
28. List on 28.
This 28.
28.
28. And same is for item number 28 also.
28.
Yes.
28 also same order.
Yes.
Call for the case diary. Same order, 28.
Obliged.
Highly obliged.
Twenty-nine. Not yet ready. Huh? Huh? Oh, file not received. Yes.
Your Lordship, appeal is there, one appeal is also listed.
29.
Appeal item number. Last item.
A criminal appeal.
Item
Yes,
number.
Lordship. Lordship,
No, record has not come. You wait for some time.
okay.
I will take it up at 2.
Yes,
Okay,
yes, Your Lordship.
Okay,
By the
Lordship.
time record will come.
Yes,
Okay, Your Lordship, deeply obliged.
Okay. I will admit it.
Yes, sir. Lordship, I'll just not take more than 5 minutes. Here, Lordship, I will take your Lordship directly to the FR page 32, Lordship. In the appeal, Lordship. Page 32. I'll read the subject only, not the body of this one. FR against Gunchi Lora, son of Soyang Lora and Bongali Lora. Lordship, may kindly see FR, this is Gunchi Lora, my lord. This is the appellant here in now. Now, in the appeal, this Lordship just point his name, Gunchi. In the FR, his name was Gunchi Lora. That's the point I want to Your Lordship, the contradiction in the statement and the FIR, Lordship.
All right, I will admit
Yes,
the appeal.
Lordship, because in the IA we have prayed for.
For IA, notice will go.
Yes, Your Lordship.
Heard Mr. P. Tapu.
Yes.
Appearing for the appellant. Heard Mr. T. Ete, the learned additional people for the state of Arunachal Pradesh. The appeal is admitted for hearing. Issue notice. No formal notice is required to be sent to the respondent number 1 as because Mr. Ete has accepted notice. The appellant shall take steps for service of notice upon the respondent number 2 by registered post with AG. Call for the LCR. List after 4 weeks. And in the IA, same order. Same.
Your
LCR
Lordship,
is not required.
Your Lordship, the party which they have implemented is whether a victim or the complainant.
Complainant.
Then victim has to be implemented, Your
No,
Lordship.
victim has-
Complainant is not required, victim.
Victim has to be implemented.
Yes, Your Lordship. Complainant not required.
Victim is required. Heard Mr. R. Tapu, appearing for the applicant. Heard Mr. T. Ete, the learned additional people for the state of Arunachal Pradesh. Issue notice, no formal notice is required to be sent to the respondent number 1 as because Mr. Ete has accepted notice. Para, Mr. Ete points out that the respondent number 2 is the complainant. But in this case, the victim has to be made included as respondent number 2. Therefore, the applicant is directed to implead the victim as the respondent number 2. Least up to 4 weeks.
Deeply obliged, Your Lordship.
I also, Lordship. I also.
Deeply obliged.